Federalism. Besides establishing a balance of power among the three branches of government, the Constitution also maps out the relationship between the federal government and the states in 2 articles and 1 amendment. In Article 4, the term full faith and credit is used to describe the mutual respect and legality of laws, public records, and judicial decisions made by states. In effect, if Nevada has laws establishing rules for marriage and divorce, New York must recognize those laws as valid. In the case that state laws do conflict with each other, the law within each state is recognized as legal for that state. By extension, Section 2 recognizes that the citizens of each state shall be entitled to all the privileges and immunities of citizens in all the states. This provision is significant because it guarantees that the rights of a citizen in one state will be respected by other states. The phrase privileges and immunities becomes a significant phrase in the 14th Amendment, where states are told they cannot abridge the privileges and immunities of its citizens. States also recognize the legitimate claim to its fugitives through extradition. Finally, in Article 4, Section 4, the United States guarantees every state a republican form of government. The use of the word republican is important. It suggests that every state must establish a limited representative government. It also guarantees that the United States will protect every state from outside attacks or internal strife. Perhaps the most significant statement that defines the relationship of the federal government to the states is found in Article 6. The Supremacy Clause states that the Constitution and the laws of the United States shall be the supreme law of the land. In effect, this clause tells the states that they cannot pass laws or pursue actions that come into conflict with federal actions. It also refers to all state officials pledging their allegiance to the Constitution. The court case of McCulloch v. Maryland in 1819 established this precedent when Maryland was told it could not tax the national bank. The concept of federalism, the overall relationship between the federal government and the state governments, is defined in the 10th Amendment of the Constitution. It specifically tells the states that they have reserved powers. Powers not delegated to the government by the Constitution are given to the respective states. The application and interpretation of this relationship will be fully explored in Lesson 4, Federalism. By including language that gives legitimacy to state governments and establishes a defined relationship among the states and between the federal government and states, a federal system of government is formed. Throughout the entire document and in the amendments, both the federal government and state governments are told they do not have unlimited power. The three branches are limited through the systems of checks and balances. The Congress is told that it cannot deny the right of habeas corpus, the right of appeal, or pass bills of attainder, predetermined jail sentences imposed before trial. There are, however, exceptions to some of those limitations. In times of national emergency, the Supreme Court has determined that the federal government can place major restrictions on the civil liberties of its citizens. During the Civil War, Lincoln suspended the writ of habeas corpus in the border states. During World War II, Roosevelt ordered Japanese American citizens living on the West Coast to internment camps. In fact, the entire rationale for including a Bill of Rights in the Constitution was to reinforce this concept of limited government. From the opening words of the First Amendment, Congress shall make no law respecting to the due process guarantees of the Fifth and 14th Amendment, the government is told that the rights of its citizens must be protected. A further examination of this issue will be taken up in Lesson 5, the Bill of Rights and Civil Liberties. This principle of limited government is the end extension of the philosophy of the Enlightenment thinkers, that government is created by the consent of the governed. If people have natural rights, it must also be assumed that government cannot take those rights away.